Good evening to United Kingdom and United States lawyers, academics, rappers, distinguished guests, brothers, sisters, friends, and the state. And we know the state is listening, and tonight we ask you to record this. Stop the prosecuting of rap. Stop the use of racist stereotypes in and out of the courtroom. You are on the wrong side of history. Making music isn't evidence of crime, but the prosecuting of it is. As a result, the state creates unsafe convictions, perpetuates racist stereotypes, and restricts artistic expression. The state knows that studies have consistently shown that the deployment of rap to prosecute a defendant prejudices the jury against, more often than not, the young black lad in the dock. It's brutal, it's cruel, it's unfair. It's time to stop abusing your power. 20th of January 2021. What a historic, important, and magnificent day. If only you could see yourselves, loads of black, brown, and white lawyers, artists, defenders, prosecutors. What a fantastic, high quality, high caliber audience. Never before have so many incredible people gathered together for such a significant event, which in time will change the legal landscape for the use of rap in criminal proceedings. The special relationship has been rebundled and rebooted under the big tent of rap. And bloody hell, it really is a big tent. We have all gathered with common cause, and mark my words, one way or another, we're going to liberate rap from the legal system and put it back where it belongs. On the day we have the first black female vice president of the United States of America, we start the second set of Black Lives Matter webinars from Garden Court Chambers. We are so very proud to be able to do our bit, like so many others, in fighting racism. We will cover topics and have a plethora of speakers standing up and speaking truth to power. So please spread the word. As a 50-year-old lawyer, I can give you a bit of advice. If you want to know more about this topic, read Rap on Trial with a foreword by Killer Mike. And before the police go off and arrest him, he's not really a killer. You laugh, well, a few of you did, but the state has and continues to prosecute predominantly young black men on the basis of that sort of simplistic approach to rap and rap artists. Before we start this webinar, I have got to caution you all. Everything we say today will be taken down and will be used by us to win any rap trials the state may bring either side of the pond. There is no option for anyone to remain silent. In fact, we have to start to make a hell of a lot of more noise. I can hear this panel revving up to kill you with their eloquence, knowledge, clarity, and wisdom. And so from the United States, we have the incredible Andrea Dennis, a former assistant federal public defender who holds the John Bird Martin Chair of Law at the University of Georgia School of Law. The amazing Eric Nielsen, associate professor at the University of Richmond, who has testified and or consulted in more than 60 cases. And the well-renowned John Habasaki, a civil rights and criminal defense attorney, whose significant recent cases include representing rappers Laz the Boy and Drakeo the Ruler. All the way from the United Kingdom, we have the phenomenal Cecilia Goodwin, solicitor advocate and Stevenson solicitors, who recently appeared in the BBC documentary Defending Digger D. Digger D was served with a criminal behaviour order that controls his creative output, meaning he's not allowed to release any music or videos without telling the police. The second UK speaker is the brilliant Shahida Begum, a specialist criminal defence barrister from Garden Court Chambers, who has defended young defendants in joint enterprise cases raising gang and drill issues. Today, we also want to hear from rappers, from the artists themselves. Lawyers, academics, and experts only know and understand so much. So we need your help now. We need to hear from you. We want you to educate us. We want you to educate us all. And we also want to hear from the lawyers operating at the sharp end. There is a lack of data in terms of what is happening on the ground. And we'll send out a poll now to get a snapshot. Please fill it in and we'll review the answers later on in the webinar. There's also a chat function. So please, as the webinar goes on, if you've got a question or an observation, please log it. So now to the sound of an imaginary looping drill beat and a massive round of applause. Let's kick this webinar off with Andrea. And Andrea, I just wonder whether you can tell us just a little bit in terms of the history in relation to how the state has prosecuted defendants using rap lyrics or videos. As I understand it, you published a paper maybe a while back now, but you can tell us the date. I think it was 2007. Can you just give us that outline, please?
Sure. So first, let me just say thank you to Garden Court Chambers, and in particular, thank you to Kier for organizing this and inviting me to participate. It truly is a delight to be here to talk with my colleagues across the pond and ordinary folks across the pond as well about what is clearly a global international phenomenon that is deeply disturbing and troubling. So let me just, as Kier asked, give a little bit of the history about how I came to be involved in this, and Eric, and some of the major historical points over almost the 20 years, right, since I actually became aware of this issue. So I first encountered the tactic almost 20 years ago, as I just said, in the early 2000s when I was a federal criminal defense attorney. At the time, a colleague of mine in the office had a capital case, a death penalty case involving rap songs that his client had allegedly recorded on some CDs, right, which tells you how old this practice is. Those CDs were recovered in the course of searching some of his property. And when the evidence was provided in discovery, we became a little concerned in the office that this was potentially going to be used against my colleague's client. That case ultimately resolved short of trial, and so the issue went away. About 5 years later, I had entered academia, and the issue landed back on my radar. I was researching connections between hip hop and the law. A new colleague of mine at the University of Kentucky College of Law mentioned an ongoing capital case in a local courthouse in which the defendant was accused of killing a music store clerk. And the defendant was an amateur artist. He had been writing rap songs for quite some time. And the prosecutor in that case was pretty aggressive and was planning to and actually attempted to introduce lyrics to prove that individual's guilt, but also that he had a extremely dangerous character, and he was essentially just a killer, and he warranted the death penalty. And so this led me to think, well, this might not be an isolated incident, right? So I had heard of one incident in practice and seen another going on real time, and I just began some research. And so ultimately, my research in at the time Westlaw, the most commonly available legal database. Right, internet searches weren't really that much of a thing, right? I found dozens of these cases, and so I wrote this article that Kier mentioned, Poetic Injustice, and published it in 2007. And so one of the major upshots of that article was I suggested that defense counsel should be able to have their own experts to counter the government's experts, the law enforcement gang experts that were being called on to interpret lyrics and to opine on the criminality that was supposedly alleged in these lyrics. And so I put the project down for a little bit, but then fast forward to around 2012, and Eric Nielsen, right, who's also obviously here today and will give you some information, reached out to me because he had stumbled across the issue going on in the UK. And so the next year, Eric began to serve as an expert in court on these cases and consult on these cases. And as Kiera mentioned, we later published our book, Rap on Trial. So that's a little bit of sort of how this issue even landed on my radar, how it began to be an issue that especially Eric pushed here publicly in the media. And so it is almost 20 years ago. Let me just say a little bit about some of the earliest cases we found. Initially, when I did my research, the earliest case we found was a case of United States versus Foster, a federal drug distribution case that was prosecuted in Chicago, Illinois. That case resulted in a published appellate court opinion in 1991, which I found on Westlaw, and was central to the article I published back in 2007. And so for a long time, we thought that was the first case that we could identify. We were certainly not declaring that to be the first case ever. It was just the first that we could identify. Recently, we learned of another case that happened a couple years earlier in 1989 in Michigan. And this case involved a defendant who was 15 years old, but had been charged as an adult with first-degree murder. And the rap evidence in that case was allegedly a set of lyrics that he copied into his notebook, right? And these lyrics that he had copied down, presumably from some other artist, were used to establish his premeditation. He was ultimately convicted at the age of 16 and sentenced to life without parole. One of the reasons this case might have become apparent to us now, many years later, is because there has been ongoing for many years here in the United States an effort to challenge life without parole sentences for minors. And so the media has focused significantly on it. And so it's likely that this case received significant attention recently, whereas it may not have before because of this issue of life without parole. So right now, right, our estimation is that at least the earliest documented case that we can find is 1989, and sadly involves homicide and life without parole for a very young man at the time. So we can say the practice dates back to at least 1989, right? The timing of the practice tracks alongside the birth and rise of the commercial popularity of gangsta rap here in the United States. I won't say too much more about it. I'm sure we'll come back to that. But that's pretty significant, we think, from a socio-historical legal perspective. I would also say that by 2004, it was clear that prosecutors believed that the use of rap as criminal evidence was an effective strategy. We see them in prosecutorial training manuals that were shared nationwide, making comments about the ability to use this evidence to paint the defendant's character as a thug, as a criminal, right? Encouraging law enforcement to look for this type of evidence because it will be helpful in achieving convictions and serious sentences. So prosecutors, at least by 2004, were publicly acknowledging this practice and spreading it throughout their communication networks. So I'll end by just talking a little bit about today, which is to date, we've identified over 500 cases nationwide and at the federal and state level. We have identified these cases from commercial databases still such as Westlaw, but now also media reports, which are much more readily available online, and plenty of word of mouth. 500, we believe, is just the tip of the iceberg. This is just what we have been able to identify and begin to collect some data about. We hear consistently from public defenders that they've handled cases. Of course, they haven't given us necessarily the data about those cases, or we hear from prosecutors, well, I had, X number of cases. So we know that there are plenty of more, thousands, if not tens of thousands of these cases. As you heard, Eric has been an expert or a consultant on more than 60 of these, including capital cases and death penalty cases. I've trained hundreds of attorneys and consulted on numerous cases, including capital cases as well. And our research, whether it's my article and hopefully maybe our book at some point has been repeatedly cited by practitioners and judges in briefs and court opinions. So I apologize, that's a little bit lengthy, but I think that gives a pretty good high-level overview of what we've seen from almost 20 years of thinking and researching and practicing in this particular area.
Andrew, thank you very much. And I think, I don't know how many people remember tapes, but I think 1989 takes us back to the use of tapes. And it's a sad thought that for, in fact, 30 years, the state has been using lyrics to prosecute predominantly young black lads. And it's a real sadness, is it not, that that first case involves a 16-year-old. Now, I'm going to try and compare and contrast, and we'll do that with a number of these questions. The situation over here in the United Kingdom, and I'm just going to ask Shahida effectively to do the same thing, but from the UK perspective, just a thumbnail sketch of the use of rap lyrics by prosecutors, by the state in the United Kingdom. So, Shahida.
Thanks, Kev. Well, it's been a similar trajectory in the UK, albeit quite a bit later. The first case that mentions the use of lyrics that's reported in any of the official law reports, so this would be at the appeal stage rather than first instance, dates back to 2005. And it's actually a really unusual case where, again, it was a youth who was involved and the offence was attempting to aid and abet suicide. It's not clear from the actual judgment what genre of music it was, but it's described as a genre that's popular with many young people. And in that case, the use of the lyrics wasn't actually challenged. It made its way to appeal because of the challenge to the actual offence and whether that offence was appropriate for the circumstances. But certainly since that first case, there's been a massive explosion in the use of this material in relation to rap and its subgenres. By 2007, there was a reported case that specifically related to rap music. And now it's pretty much, it feels like in every single case that involves joint enterprise stabbing or firearms, particularly it seems to be when it's young black males, the state has tried to use this type of evidence in as bad character material. And I think that's reflected by the fact that of the 30 reported cases that we do have in the UK, in the official law reports, the most recent 10 has been between 2018 and 2020. So that's in 2 years, there's been the most recent 10 cases out of 30. Now, it may be the case that it's more people who are challenging the use of these lyrics, but I think more likely it's also reflective of the fact that it's being used perhaps too widely in these situations. Certainly as well, from speaking to other practitioners, it would seem that around 2005 was also first instance decisions when the state was trying to use rap lyrics in trials. But one of the problems we do have, which again, Andrea's touched upon, is there actually isn't enough data. There isn't data logging of when these cases, when the state is trying to use this material. And what really needs to happen is that the Crown Prosecution Service, which is responsible for bringing prosecutions, should be logging every single case where they are trying to use this material, what's the ethnicity, and there should be a survey, a qualitative survey of what is the impact and if it is discriminatory. And just finally, I'll just mention, because I don't know if it's the same in the US, but in the UK, it's not simply a case of using rap lyrics and so forth in criminal trials. Sometimes, even if somebody has been convicted of an offence and it's not to do with the music video, the prosecution can apply for what's called a criminal behaviour order, which stipulates certain conditions which can limit an artist's ability to make music. Sometimes, even when they aren't charged with any criminal offence at all, the state can apply for a civil injunction where they suggest that somebody's involved in gang-related activity and again limit an artist's ability to make music. And finally, steadily since 2015, the police are making requests to YouTube to remove certain content. And on hundreds of occasions, YouTube have removed that content. And it doesn't seem to be that YouTube or the police have actually given the artist any opportunity to make representations of why their content should be removed. So again, it's a similar picture. Now, I was going to just, I don't know if we, Keir, if there is enough time for this, but there is one of the cases that did gain a lot of media attention in the UK, was that there were two artists who were a duo, Skendo and AM, who did receive a gang injunction. And then they actually went on to perform a song at a music venue in London, a very famous, well-established music venue, etc. And the police said that by performing that song, they had breached their gang injunction. And in fact, they were taken to court and received a prison sentence, albeit it was suspended. But they did actually make a song talking about their experiences in relation to that. And I was hoping that we could just play that very short clip if we have time.
Well, of course.
SKENGDOAM and we come from south. I used to kick ball with all the man them or 1-2 game of run outs. Then the fields got knocked down. KMT, where we gonna play out? So we started hanging around, congregating, feds racing us down. We're trying to make this happen. It would be peak if I was not rapping. Feds they're moving all weird. It's like they love the harassment. Cowley Estate and North Mightfield is where I grew up with the crashers. Stereotyping loud, we all know that you can't stand my blackness. No, they can't stand my blackness. See a black you and they all think stabbing. You don't even know this guy, he wears a tracksuit so you think he's trapping. I got 9 months suspended for rapping, still can't believe that happened. Freedom of speech, don't have it, just one day in my shoes, you can't hack it. Bro wanna make some money, there's no job, would you help him out? They don't wanna help him out, so he hit the trap and he's in jail now. Guy just try to survive, make sure they're good, put food in their mouth. It's them man there that got a good butt, wanna act and do it for clout. SKENGDOAM and we
It's a very good example of what a brilliant lawyer Shahida is, because we didn't really have a choice there. We had to play it. But we encourage, I think now, hearing from both sides, those that are listening now, please fill that survey in. There's a sketch there being given by the speakers on both sides, but we need more data. So please fill that in. It's been circulated and we'll look at it later on. But it's a worrying trend on both sides. And it now moves to the next sort of topic as to why. Why has the state on both sides of the Atlantic decided to prosecute? And I think we need to look at that and also the impact, maybe the impact on youngsters, on young musicians. And maybe the best person to start us off here is you, Eric. Can you consider that particular topic and give us your thoughts on it, please?
Sure. And I want to echo Andrea's comments. I'm also grateful to be included in this, and want to thank you for drawing attention to what you rightly describe as an unjust practice. I think before I answer your question directly, I think it's useful to put this practice in a broader context. Yes, the use of rap lyrics in criminal trials or in the criminal justice process is a relatively new phenomenon, but it resides within a very long tradition, certainly in the United States, of punishing Black expression, Black speech. That's what we've done for a very long time. As long as there have been Black people on American soil, that is how their speech has been treated, as threatening and in need of regulation. And so while this is new in terms of the actual logistics of it and the practices, it is really just a new permutation on a very old dynamic. Now, getting to your question directly, why? I mean, the simple answer is it works. It's very effective for prosecutors. They are able to play upon and perpetuate enduring stereotypes about young Black and Hispanic men. They are able to do that in order to secure convictions, even when in many cases other evidence is lacking. And we know, based on a number of studies and common sense, but we know that these rap lyrics or videos are highly prejudicial. Keir, you spoke to this earlier. They are inflammatory, and that is the entire purpose. Prosecutors are introducing them so that they can get a guilty verdict. And we know, for example, that this is unique to rap music, certainly in the United States. Andrea and I have done a whole bunch of research, and this is a rap on trial phenomenon. It is not music on trial. And it's no coincidence that the overwhelming majority of the defendants in these cases are young men of color. That shouldn't probably come as a surprise. And we also know that people in the United States, certainly, often have very negative views of rap music. And in fact, this has been the subject of a variety of empirical studies. And I'll just give you one quick example. In 1999, social psychologist Carrie Freed conducted an experiment. And in this experiment, she took from a folk song, she took some violent lyrics, okay? And she took the lyrics and she put them on a page, stripped the page of any identifying information, didn't say what genre the lyrics came from, didn't say the name of the group, just words on a page. And she handed those lyrics to two different groups. She told one group those lyrics came from a rap song, told the other group that those lyrics came from a country song, exact same lyrics. And what she found is that the group that believed that the lyrics came from a rap song found them to be significantly more threatening and in need of regulation than the exact same lyrics that were labeled as country music. And so that really starts to explain how this works. You play on racial stereotypes, you secure convictions. And then as other prosecutors see that this works, as Andrea noted, they share this practice formally and informally, the practice begins to grow. And unfortunately in the United States, although there have been many challenges, generally speaking challenges at the appellate level, for example, they fail. And so you have a combination of a highly effective practice for prosecutors and what has so far been an inadequate resistance to the practice in the US. And so I'll leave it there, Keir.
Thanks very much. We're getting a lot of questions through, but I'm going to store them up for a while, just so we get as many of the panelists speaking as possible. But as a result of what you said, there's a lot coming through there. Thank you very much, Eric. And can I turn over now again to the UK and ask Cecilia to answer the question from a UK perspective? Why is the state over here using rap lyrics to prosecute?
So I think in relation to the UK, I think most of what obviously Eric has said will mirror what's happening here. But the justification given by obviously the state here, the police, in relation to using mainly drill, it's drill lyrics, why they are focusing on that. And the reason they say that is because it's an attempt to curb violence and also curb the incitement of crime and violence. So in essence, their justification is not only are they going after people who are going through the processes of trials, but also they're trying to make sure that they're controlling the output of certain types of music when people aren't even facing trials. So, for example, when people are just trying to make music and make money and obviously proceed in terms of a professional life as an artist. The issue that we have then is that it then generalizes a whole genre of music. So immediately the thought is, well, actually, this is music that is drill. So therefore drill equals bad, and everything that comes out of drill is bad. And it's again playing into the perceptions of the racial injustices, the kind of portrayal of young Black boys and what they do and what they're up to and why they should be feared. But obviously the implications and the ramifications of that are quite serious, because the most obvious one is that there are unfair convictions which are obtained on the basis of these rap lyrics, drill lyrics. But moving on from that, when you have people who aren't even going through trial processes, for example, it curtails their freedom of speech, freedom of expression, and obviously it's a way of censoring what they can and can't say. So it's censorship by the state, which then in a way sort of deters society, as in the wider society, as in the record labels and so forth, wanting or even thinking about getting involved with artists who put out music which is deemed to be negative, which is deemed to be dangerous, which is deemed to be unattractive. Because what record labels want to work with a genre of music that is getting such a bad rep in the press and in the wider society? So it then means that record labels, brands, they don't want to get involved with young kids, let's face it, young Black boys who are doing this sort of music in order to better themselves and get out of poverty. So it means that the social impact is that it's a way in the end that keeps these young musicians in a cycle where they're unable to obviously leave the confines of poverty, and they're in a cycle of crime. So the ramifications for us in the UK are quite serious, because we're not only seeing it in relation to those who are facing trials, but it's also those that are actually trying to get out of poverty, or, for example, who just enjoy drill. And the irony of this is there are actually examples where some artists, drill artists, will be quite successful, but actually they've never lived the lifestyles that they talk about within the context of their music. And that's when you just think, well, what is the basis and the reason for all of this, for this trajectory that we're facing in relation to this sort of music and attacking drill music and rap music? And I think that's what I would say in relation to that question.
Well, thank you very much. The problem is we're now about a third of the way through, and I'm feeling really down. In terms of what we've established so far, it's very depressing, and it seems to me that it started off badly in the back end of the 80s and into the 90s, and it's getting worse, and the reasoning for it is horrendous. It's racist. So, Andrea, it's your job now to give us a bit of positivity, please, in terms of some successes. We want to have a bit of good news. For once, please, from the United States. Can you cheer us up, please?
So I'll try a bit, right? I think any criminal defense attorney knows, whether you're in the US or UK, that part of thinking about whether you are winning or you're having success, right, requires you to redefine what it means to win, right? But we are making some inroads. Maybe a little bit on the downer side. I will say that success has been few and far between, but again, there have been some particular instances of success and some broader changes that are positive. I'm going to talk just a little bit broadly rather than identifying particular cases, and certainly either Eric or John might weigh in on particular cases they've worked on that have been successful. So on the trial level, what we've seen in terms of success or wins are a number of things. So one, we've seen, for example, when the government is confronted with the fact that defense counsel is going to seriously challenge evidence at trial, either by raising objections or, more importantly, by offering a defense expert such as Eric, right? We have seen instances in which the government withdraws the evidence, right? Withdraws the notice that they are going to seek to offer this evidence, which is a significant win, right? Anytime you can push the government back on its heels and force it to change strategy, that is significant. So we have at least seen one instance of that, and there likely are plenty of others we're less familiar with, in which just defense attorneys indicating serious efforts to challenge either pretrial or at trial alter the government's case. We have also seen some instances at the trial level of acquittals. Now, not outright acquittals on all charges, right, but on some of the charges, and in some instances, some of the most serious charges, right, notwithstanding the fact that rap evidence has been admitted. And then finally, there have been instances of outright acquittal. And again, these are those where they do involve serious defense efforts to challenge the evidence, defense efforts to offer their own expert testimony that will inform the jury. So, as on the whole, on the trial level, right, again, we've seen sort of, right, strong defense challenges will either lead the government to withdraw the evidence, they will potentially lead to acquittal on some of the charges, even if not all of the charges, when the evidence is admitted, and in some instances, outright acquittals. Again, fewer and more rare than we would like, but significant nonetheless, certainly for those individual defendants, significant. On the appellate level, again, we've seen some movement. So I mentioned, of course, that we are seeing practitioners more frequently challenge either at the trial level, but also on the appellate court level, and citing research, making strong arguments to appellate courts for why admitting the evidence was erroneous. And then what we have seen is, in some instances, appellate courts reversing, right, the lower court decision to admit the evidence. And in these opinions, the appellate courts have concluded that even if the evidence was relevant, which again, I would take the position, I think many of us on this webinar would take the position that the evidence is irrelevant, but even if in the appellate court's estimation, the evidence could survive a relevance inquiry, that it was erroneous to admit the evidence because it was unfairly prejudicial. So we have rules, much like from what I hear in the UK as well, right, that even if evidence is relevant, if it's going to be unfairly prejudicial to the defendant, then it can be excluded. And so some appellate courts have found that trial court judges erred, right, when they were conducting their analysis of unfair prejudice. And this is important because it's not only that they're finding that it was error to admit the evidence, but that it was reversible error, right? It was not harmless error. In US cases, we have a rule that says if the error occurred, but it was harmless, well, then we'll still allow for the lower court decision to stand. And so it's significant when an appellate court says this was error to admit the evidence that was not acceptable and that was not harmless. What we have also seen are some instances where the appellate courts have not ruled in favor of the defendant, but they have at least opined or suggested that the government's law enforcement testimony, in particular its gang testimony, was improper or not necessarily rising to the level of error, but they have critiqued or questioned the government's use of this type of expert testimony. So again, in the appellate courts, we are beginning to see some movements, at least more searching inquiry, both at the trial court level and the appellate court level, which we hope and expect, right, as we continue this effort, will lead to more and more either trial court decisions to exclude the evidence or appellate court decisions to reverse trial court decisions.
Andrea, thank you very much. And that's certainly cheered me up to hear that positive news. And I think the lesson to be learned is, certainly as lawyers, we need to be proactive. We need to be instructing experts early on, and we need to take the argument and not give up, take it all the way to the highest court. I'm going to turn back to the United Kingdom. Cecilia, I'm going to ask you the same question. I have an inkling you might be playing a bit of a video, but the deal is you're going to have to maybe edit a little bit of what you're going to say, so we can fit in everything that we need to for the rest of the webinar. But over to you. Positive news, please.
Okay, so I don't know if we can play the video now, and then I can chat after that.
When Digger come out of jail, he said to me, I can't rap anymore. He said, look at all the things you're saying I can't say. If anything, it's a challenge to bring out the art out of you. I said to him, if you can only rap by saying these words, then you're not an artist.
The CBO told me I can't say certain things. Can't talk about my upbringing, what I've done, what I've seen, and what I've been through and that. But at the same time, it's helped me out as well, because now I can't talk about violent stuff. That's not what the radio want to hear. They don't want to hear violent stuff.
And now I can rest in peace, just like my pagans.
Thank you so much for that. So that was from the documentary by my client, which I featured in, called Defending Digger D. And in essence, what I would say as an achievement was that, having obviously been part of the documentary being aired, it has put the subject of CBOs, it has put the subject of drill music, it has put the subject of young black boys in music, young black boys on the streets, in the limelight. So now people are talking about it. You know, it's now a topic of discussion. It's a topic in a lot of people's awareness. People that would never have known that these sorts of things happen, would never have known that the state have powers in which they can actually dictate what somebody can and can't say in their music in an artistic way. So for me, I see that as an achievement, as a success, in that we're at the beginning with our fight in the United Kingdom in relation to the censorship of music, the censorship of drill music, of rap. But at least we now have something that is moving the debate on, that's making people understand that actually there are things happening in the background that a lot of us don't know about. I mean, it's so much so that obviously, in terms of everybody talking about it, the police also released an article in a newspaper, Evening Standard, on the 6th of Jan, if anyone wants to read that. And basically it was their version, I guess, of saying why CBOs are necessary, and it's obviously as a result of the documentary. But the main thing is both sides are now having a discussion about the issues, that we still have a lot to fight about, and we're just at the beginning. So yeah, that's still a lot more to do.
There's a lot more to do, and I know that there's a lot of media interest. There's a lot of reporters listening in today, and I think we urge them all, as part of their own moral duty, and I'm sure they'll do this, to publicise what we're talking about. Very real and important issues. And it'll take some time, as you say, but eventually, as I said at the opening, we are going to change the legal landscape in relation to the use of rap lyrics in the courtroom. And so appropriate time maybe to go to John and ask John the question about what can we actually do to combat the state's approach. We've heard about two very high profile cases. Maybe you can give us a bit of an insight, given that you were victorious. Can you tell us how you do it?
Thanks so much, Keir. Thanks to Garden Court Chambers and all of the really powerful presenters that we have on today. I didn't know quite how this was going to go, meeting everybody from across the pond and, just hearing from everybody and the enthusiasm, especially with Keir's opening about pushing back and fighting against this practice. That is exactly what we need. We need to start having the broader dialogue within the community, through the media, and change the minds of people about the acceptability of using rap lyrics in criminal prosecutions. So myself, I'm a trial level attorney, meaning I generally don't do appeals. I do some, but mostly I'm in the courtroom, I think like Keir, Cecilia, and Shahida. And I came across this issue probably 12 years ago when I first saw it. And the first time I saw it, a young prosecutor tried to bring it in on a gun case, and the judge essentially laughed him out of the courtroom, which is, I think, the goal or the point where we should get to. Like, the idea that it is acceptable to use somebody's artistic, their music, that it goes against everything that I think we believe in as far as, our ability to create culture, our ability to create meaning in life. And when we allow the state to weaponize that, principally and essentially in this case against young Black men, I think we have to be direct about calling it what it is. And, race is always a difficult conversation in the United States. I assume it's probably challenging in the UK as well. But the practice, I think Cecilia and Eric and Andrea discussed how the prosecution had tried to use it, the justifications. I think we have to just call it out for what it is. And it's a racist practice. And it's based on all of the historical racial inequities that Eric talked about within the United States. And I imagine different, but in the UK as well. So, from the very outset of a case, being filed in a criminal courtroom, we can't accept it, and we can't accept the state's justification that it's there to prove their, criminal nature, or that they were more likely than not to do this criminal act. Because, when you think about what it does to a community, right, where in the United States, primarily the artists that are producing this are coming from poor, impoverished, dangerous, violent communities, and they've grown up in this. And so they found this way to create art from all of this horrible terror that they've grown up in. And then the state is going to turn around and punish them for creating, some beauty out of all the destruction that they've grown up in. So accepting, any of the state's justifications, I think, is something that we should never do at the outset. And then, the question is really how to talk to a court and a jury about the prosecution's attempt to use these lyrics against young Black men and to prosecute them. And, there, I think, for me, in the cases you've mentioned, I've had success. The Draco case is probably the most recent and the biggest, because that case started off, and there's lots of articles and stories about it, but it was really about a detective who believed that because somebody's rapping about guns and violence and drugs, that this is what they were doing, right? And in Draco's case, that really wasn't the case. There was nothing tying him to actually the commission of the murder, but they went ahead and charged him with capital murder, prosecuted him, seeking the death penalty, although they later withdrew that. And it was all really about him being an artist, him coming out of South Central Los Angeles, and making a big name for himself, being on the front page of the LA Times style section right before he was prosecuted. And really what I did in that case, what I thought was successful, was to absolutely, to the jury, I don't know how to put it better than to say openly mock the prosecution for doing this. Like, I just give them zero respect for their attempts to paint a young Black man in a certain way because of the use of their music. And it was a pretty adversarial case and trial, but across the board, we were talking before the presentation, 3 Black jurors who were excused, meaning kicked off of the jury, because they got so upset and spoke out about the prosecution during the case. It was an outrageous case in every way, but as a lawyer, in pushing on that, in making it apparent to the jury, and talking about it in opening statements, I think that was one of the keys to victory, was to really taking it head on, not sort of just being like, well, these are really bad lyrics, and he shouldn't do that. And I think it's coming from like Kier growing up listening to those cassette tapes of hip hop back in the days. That was my era, my genre. And when I got a case, I was like, I can't believe they're actually doing this. They're using it. And so having that language, being able to discuss it, right? So I reached out to Eric as soon as he published his first piece in the New York Times. Andrea's piece was one of the first I referenced. So also building this community of experts that you can rely on, that you can talk to, that you can consult with and work through, I think have all been keys to being successful in the litigation of these cases.
Well, thanks very much, John. And I'll be interested to hear from Shahida now about whether she's going to, or does already, I don't know, use those sort of tactics in terms of the prosecutor or speaking directly to the judge. What do you do in court, Shahida?
Well, unfortunately, in the UK, we can't actually have direct conversations with the jury. Sometimes it would be great to do that, to find out what they're thinking. But in the UK, the jury aren't actually allowed to state what their opinions are in the case whatsoever. So when they're told to go off and decide, they will actually have their deliberations in secret. And even after the trial, they'll be told that they shouldn't discuss what the deliberations were. Obviously, if they had any particular concerns that related to the case, they can bring it to the judge's attention. So my battle normally starts with the actual prosecutor and the judge. And what I would do is firstly speak to the prosecution and see, is there actually something that we can agree on? So are they actually being reasonable in trying to include, because in the UK, what's happening at the moment is it won't just be the lyrics and the videos. There'll be other content from social media, text messages. There's just a whole raft of association, people that they've been seen with. So trying to narrow it down, well, what do they actually want? Because if it's simply the case that they want to prove that somebody knows somebody else, another defendant in the case, there may be a way of doing that without having to resort to having to have a legal argument about it. And then, of course, making all the submissions to the judge that you needed to make. But I think just more widely as well, in terms of combating the state's approach, I think the first thing that we need to do is obviously talk about it, which is what we're doing now. But it really does make a difference, because in the UK, there are still lots and lots of defense lawyers who either don't realize this material can be challenged or how to challenge it. A lot of them let it in and will make some sort of comment about it. Normally, the example they use is, I shot the sheriff, or Marley didn't actually shoot the sheriff, but that's as far as it goes. that's not enough, and they need to educate themselves as to that actually there's more that can be done. And certainly after part 1 of the Garden Court seminar series, I've seen at least 4 news articles about this topic in mainstream outlets. So that's brilliant. The second thing, what we really need to do in the UK is build up the capacity on the defence side, because we are playing catch up. So we do need to build these networks, these connections, identify who are the experts, so that when we are instructed, and often it can be last minute, there's somebody you can call on the defence side to give evidence about it. And this is really important because there is an imbalance in the UK between the prosecution and the defence resources. At the moment, whilst I was researching for this seminar, I've come across that the police not only have a social media team who are looking at music videos constantly and the ones they want to remove, they've got a supposedly translators of drill music team, even though every different region or every different London borough might have their own nuances of language. And not only that, the most troubling is that they actually have a team with one of the universities in London where they're trying to develop software that decides on what's the dividing line between violence and free speech. There's actually a quote from an academic in a newspaper article who said that we're seeking to develop a tool that can automatically discern harmful content from legitimate artistic expression. I mean, that's just quite shocking, because how can you get a robot to make that sort of judgment call that's so important? And then just very briefly, what I've mentioned before, we need more data recording. We need a government-funded research program into how this evidence is being used. And if it's, we know anecdotally it's not fair, but there needs to be proper research on it. And also what we need is the young people that it affects, give them a platform to engage in this discussion. It shouldn't just be once they're in the courtroom and that's the only time you hear from them. There needs to be another platform. And the music industry, I would suggest, needs to become more involved, because they have actually been more successful once in the past when the police were requiring promoters and licensees to give information about music events. It was called the Form 696, and it transpired that it was having a discriminatory effect on the Black community. And lots of music industry people did speak out about it, and then the police in London said that they won't use it anymore. So again, the music industry needs to engage in this discussion.
Brilliant. Thank you very much, Shahida. Quite a long list there. And so I hope someone's been noting that down. But as ever, all of us have to join in this fight. We have to be proactive. And it clearly, on occasions, as you've shown, brings about successes. Now, we're going to move on as quickly as we can. There's a whole load of questions we're going to have to try and deal with in the last 20 minutes or so. But going on the same sort of approach in terms of attack, we're going to look at what happens in the US. Now, I think it would cause most lawyers in the UK a heart attack to, before the trial, go on television with your client and tell everybody what your defense is, and or go on to an interview as a lawyer to discuss before trial the tactics and your views on the prosecution. Well, John did do this at length, so we're going to see a little clip in relation to him, and then also following on from that, a short clip involving attorney and defendant. And then, John, you can tell us whether that was successful or not. Okay.
And so this case has already been to trial, and Draco was found not guilty on the vast majority of his counts, aside from like possession of a firearm, correct?
Correct. I mean, and to be clear, so I think it's important that people understand, from somebody who, even by their own theory, didn't know the murder was going to happen, but they still prosecuted him. They sought what's called special circumstances murder, which is essentially makes you death eligible. And they kept the death penalty on the table against Draco up until right before trial. So they were seeking death up until a few more months before trial for somebody that, by their own witnesses and evidence, did not know the shooting was going to occur, did not encourage the shooting to occur, did not want the shooting to occur.
We're going to try and play the other one, Tiny Do, I think it is, that interview, just a minute or so from that, and then we'll ask you to comment, John.
Let's put his album up, or the CD, and because, again, he is a gangster rapper, and then on the CD, right on the cover, you see a revolver and bullets. Let's take a listen, and then we'll talk about what your attorney just said.
You can get a full clip, my about to bullshit and make your top disappear like an illusionist.
Okay, so do you deny that your lyrics encourage or promote violence of any kind?
I don't think they promote any. I mean, I'm not saying I to go do this or do that. I'm just painting a picture, man, of urban street life. Like, that's it. Like, it's the studio's my canvas, basically. You know what I mean? Like, I'm just painting a picture. That's it. I'm not telling anybody to go out and kill somebody or go do something. I'm not doing anything differently than the game, say.
Okay, but here's what the prosecutors are saying, that somehow you benefited from crimes committed by other gang members as well as elevated your stature as a gangster rapper, and that's kind of the issue here. Do you agree with that?
Right. No, I don't agree with that. Yeah. I get up and go to work every day. I mean, how am I benefiting from what somebody's doing? Like, I'm not a big out. I haven't sold 1 million records or anything. And if you want to, I'm saying, people can go out and listen to the album for themselves and see, does it make you want to go kill somebody or something like that? And they can pick that. You go check the album out at sickness.net, sickness.net, and see for yourself, listen for yourself. And you tell me.
That's a good pitch.
Yeah, it looks like Tiny Do did quite well out of that in terms of maybe getting a few more sales. But John, on a serious level, adopting this tactic, proactive tactic, is it a good idea?
I think it's a case-by-case determination, right there. And I've gotten to know Brandon Duncan, our Tiny Do, through this process. And he's a brilliant young man. He's very sharp, intelligent, hardworking. Like he was saying during that, and he was prosecuted solely for his music. There was nothing else attached to it, and it was a really remarkable case. But if you even saw the framing of that, they started, there's guns and bullets on the album cover. I mean, has he ever seen a country music video? I mean, it's all guns in my, pickup truck. But it really is, you have to make that determination based on the case. And I've seen some of the documentaries about the UK cases, the drill cases, the BBC Dig a D documentary and the Truth and Consequences one. And I think that the folks out there have done a brilliant job in getting the stories out because, back when I met Eric and Andrea, people in the broader population really didn't know this was going on. And when you would tell people, they would be like, what are you talking about? They're using people's lyrics to prosecute them. And now people in the United States broadly, I think a lot more people know about it and understand the problems of it. And so it's important to have that discussion. Would I put most clients on TV before a trial? Probably not, but in Brandon Duncan, our Tiny Do's case, you can tell he's a super sharp guy, and he was able to make a good case. And does that, the judge in that case ultimately dismissed the case against him, and did all of the media around that case help the judge see that? I'll say that anybody, when they're under scrutiny, is going to be paying a little bit more attention, right? A lot of darkness happens in our criminal justice system when there is no sunlight, right? And so the light of the media really can help expose injustice. So, I think you really have to be very cautious about it. But in a case like Draco or in a case like Tiny Do, where the prosecution was so clearly unjust, I don't have, within the confines of our ethical rules for attorneys about what we can say during a case, I think it's absolutely appropriate in the right case to speak out. And I think you're doing not only your clients and your case a service, but the broader community in which we all exist.
Thanks, John. And Cecilia, you're going to call your next client and put him or her onto an interview on This Morning or something like that? We can't hear you.
I think I'll have to have a little think about that. I think he did very, very well on the documentary. So for now, I think I'll stick to that.
Okay, all right. We're running out of time, and we're literally sort of only halfway through. The next question I've got is an important one, so I'm going to invite a quick answer from both Shahida and Eric. But after that, we've got a whole list of questions to deal with, and I'm going to move to do that. And I think we're going to continue this conversation in a few months' time, dealing with the other outstanding topics. That's what I've decided to do. So the next question is, why is it important to instruct experts in relation to rap or rap and videos or gangs? And is there a distinction, or should there be a distinction between rap and gangs? So I'm going to ask Shahida first. Got to be a bit shorter than normal, and the same to Eric, a bit shorter than normal. Shahida.
Yes, there's definitely a difference between gangs and the music. Just because someone makes a drill video, etc., participate in that does not mean that they are in a gang. Often there might be people who are gang members in the video, but that's just their locality. These are people that they grew up with, etc. And it's not like they've got 100,000 or £1 million budgets that they can make music videos from and hire Hollywood actors and find certain locations. They have to deal with wherever they are. So there really does need to be a distinction between gangs and the music. It's really crucial to instruct experts. Sometimes you might actually need both, for the gangs and then for the interpretation or putting it into context. Mainly, to begin with, to deal with your own preconceptions, because you make assumptions about what that music is about, when actually most people, a lot of this music is listened to by young people, is best understood by young people, or someone who knows how to put it into context. And you can use the expert evidence to not just try to exclude the material, but even if unfortunately it does go in, to put it before the jury and provide the proper context and weight to try and challenge a prosecution narrative. That's what I would say.
Brilliant. That's really, really useful. And Eric, can I have your input? Well, you're an expert.
I think it is really vital in many cases to have that counter narrative. I mean, what you have to keep in mind is that a judge and a jury is already getting a theory of a case from a prosecutor. Generally, in these gang cases, the prosecution is aided by a gang expert. And that gang expert, I will say that based upon my extensive experience in these trials, when it comes to rap music, these gang experts are anywhere from misinformed to grossly incompetent, and their characterizations of the music are sometimes laughably bad. I will give one example. I was testifying in a federal trial in Baltimore. Prosecutors introduced a picture that they got off the defendant's phone, said that the picture was of some relevant gang members. The picture was of the Notorious B.I.G. It was over 20 years old, and nobody in the room even knew that. So while my goal is to put hip hop generally and rap music in context for a jury to explain that no, it does not perpetuate violence. In fact, it was born out of just the opposite, to understand the sophistication of the genre. That's my goal, but that begins with correcting demonstrably false statements from police, which are commonplace.
Eric, that's brilliant. And again, I think the message that goes out in terms of our approach to cases on both sides of the pond is to be proactive and right at the start, where these issues might come up or clearly are coming up, that experts are instructed straight away. Now, I'm going to move to dealing with some of the questions, and we've got loads in the chat that have come up. And my apologies if we don't get to deal with all of them, because we've only got so much time left. But one of the first from an anonymous attendee is an observation that and I just quote it, "We now have senior BAME prosecutors. Surely they are the starting point to ensuring these stereotypical prosecutions are stopped." So I'm going to ask Andrea maybe first to give some thoughts in relation to that, and then anybody else can chip in with their thoughts.
So I actually think I have to defer on this a little bit, or at least get a little bit of explanation, because I don't know what a BAME prosecutor is and what their role would be in terms of stopping these types of prosecutions. So if you can help me out there, I might reflect a little bit more on that.
Well, it's reference to Black or Asian minority ethnic. It's an acronym that's used over here. It has actually been criticized as being overly general, but I think the thrust of the question is in that particular context.
Okay, so this is the equivalent of us sort of using over here people of color.
Yeah.
Broadly speaking. Okay, thank you. Got it. I was thinking that was some official form of prosecutor, a particular position. So yeah, I mean, I do think this is an interesting question, right? Whether diversification of prosecutor offices can help be a way to challenge this particular practice. I maybe have two responses. One is that maybe like other criminal defense attorneys, a prosecutor is a persecutor, regardless of color, right? Their particular goal is often, right, to obtain convictions. Their goal here in the U.S. is supposed to be to promote justice, but their goal is often to obtain convictions, whether that's their professional ethic or their particular office's focus in terms of measuring outcomes. And so regardless of race, gender, ethnicity, right, it's likely the case that a prosecutor is going to look for and use what they believe to be helpful, powerful evidence. I can say anecdotally, I certainly know of at least one Black prosecutor who has used this type of evidence in a case. And certainly there are many more, I suspect. That being said, right, there is also a group of prosecutors. There long have been some individuals who say, I'm a prosecutor of color. I am going into this profession because I'm trying to change it from the inside, right? And so I think for some of those on an individual level, they might have, right, perspectives and beliefs that would challenge their use of this evidence. But as I said, right, a prosecutor's office is a prosecutor's office. And so if your higher up says you need to do this, you need to do that, right, I think many of them find it's difficult to challenge what they believe are unfair or unjust practices from the inside. The last thing I would say is we do have what's happening here. I don't know if it's happening similarly in the UK, a wave of progressive prosecutors of all sorts of backgrounds, white, Black, Latino, women, men, but those who are focused on reforming some prosecutorial practices from the inside. So these are progressive prosecutors who are the chief prosecutors, right? So senior level prosecutors, they are the heads of offices who do have greater authority with respect to prosecution practices. And so some of them, we at least we watched the race for the district attorney in Los Angeles County, right? She's now ex, prosecutor was a Black woman who would authorize, right? Who would have authorized this prosecution that John worked on with respect to Draco, right? Who would have authorized other prosecutions, right? One of her opponents who was running was Latino, right? And he indicated in a debate that he would not, want to seek these types of prosecutions using this type of evidence. And right, John can speak to this, right? He won, right? And suddenly, Draco's case, goes away, right? So we see also if there are reform-minded, progressive-minded prosecutors who have the highest level of authority in the office, we do see some possibility for change. But again, may not be the solution, complete solution.
That's really interesting, Andrew. And obviously we have a slightly different system over here where, as far as I'm aware, no one gets elected to anything. But that's another discussion in actual fact. But Shahida, same question, just very briefly to you, as I see the clock ticking away here. Any thoughts this side of the pond in terms of BAME prosecutors at a higher level?
Well, I think there's similar issues here in that I do wonder if within the CPS, there is actually space for senior prosecutors to make their voice heard in that way and to draw upon their experiences. Because although there's an implementation with a lot of equality and diversity practices, we've discovered still there remain structural issues within any organization. And I wonder, and maybe this is something the CPS can, if somebody is from the CPS who's viewing this, can comment on whether senior prosecutors from those backgrounds are allowed to in fact provide their input and whether that would affect the decision making. But more generally, I don't think it's fair for the responsibility to be just on people from those backgrounds. I think it's everybody's responsibility to make sure that these practices are not going on. It doesn't matter what background you're from. And it's particularly important for the whole of the CPS and the police, because they do have the resources, they do have the power. And it's the same in the UK. The overall duty is to bring fair prosecutions and not a conviction at all costs. And sometimes you don't necessarily feel that that principle is being complied with. And really, I would urge all prosecutors and police to really think about the use of this kind of material in criminal cases.
So again, it's a group effort, isn't it? It's not, as you've said, right to expect people of colour, Black, Asian, minority, ethnic, to shoulder the burden here. It's all of us together, and this conversation is the start of that. I'm going to move on to another question. It's from Sharina Brown, and she asks, in relation to the freestanding civil injunctions against drill or grime, is work being done to deploy a freedom of expression Article 10 argument? So Cecilia, can I just ask you, just because obviously you're dealt with this particular topic in relation to Digger D, does Article 10 come into this in terms of CBOs?
Not when they're being applied for. I don't think they come into it at all. And I think it's something that we as a collective are going to have to work towards in terms of challenging it. I don't think that there's ever been any cases that I know of where the CBO has been challenged on that basis, but it's certainly something that, I'm interested in looking at in terms of challenging CBOs on various different levels, but mainly in relation to, freedom of speech and, expression and, your article rights. So definitely it's something that I hope we will be able to do and obviously see where we go from there. But it's definitely something that needs to be done.
The poll has been circulated. There's about 7 minutes left. If you received it and you haven't filled it in, please can you do so? It can take up to 3 seconds to complete, so allow that amount of time. I'm going to move on to another topic. This again from an anonymous attendee early on in proceedings. And I'll just read it out. I think I'll send it over to maybe Eric or Andrea, whoever's quickest on the buzzer. It says, good afternoon. Is there any academic research which has looked at whether there are correlations between songs and violence? Really interested between correlations in diss tracks and violence between those involved or named in songs. Very politely says thank you. Eric or Andrea?
There is some work. Some of it it's not always quantitative, but there's been ethnographic work looking at the correlation or lack thereof between these diss tracks and actual violence. I know that there is also research that is looking at this discourse in a more sort of numbers-driven way, to sort of look at the way that language is being used and music is being used often between feuding gang members, for example, in Chicago, to try to determine, is this music, is it inciting violence or is it diffusing violence? My understanding of the early findings is that it's the latter, that it's actually working to diffuse violence in many cases. But there isn't a lot on this, but that is what I am aware of. A couple of ethnographic works, and then there has been some emerging work, at least on the US side, and I think somebody else might be better poised to answer it from the UK side, but there has been some research related to this.
Okay, anybody else want to follow that up, or shall I go on to the next question?
Let me just say,
yep, go on.
Because I think the UK perspective is.
I was just going to mention, I'm not aware of academic research, but something really interesting that I came across is that the Mayor of London commissioned a report from the London Reduction of Crime Unit. And within that, it looks, there's reference to when there is some sort of social media tension where one group is trying to rile up another group, it actually does say that there isn't any high quality evidence to suggest that there is a link between what's happening on social media and then any later violence. Specifically, they don't have enough information about what are the triggers that may turn an online dispute into an actual physical violent episode. So I thought that was quite interesting, because that's actually, the Mayor of London is responsible for the Metropolitan Police in the UK. And that's something that you very rarely see quoted in police officer statements who are supposed experts. And really that should be included, because that's coming from the relevant office.
Thank you very much, Shahida. So I'm going to do one more question, give the results of the poll, and then some very brief concluding remarks and a 1 minute 30-second video for you to enjoy at the end. So final question here from Will Pritchard. He says, in the UK, the predominant platform for drill music is YouTube. The comments section is often filled with fans gossiping about alleged incidents the artists in the videos may or may not have been involved in. Have there been cases in which these comments are introduced as evidence by prosecutions? And for some reason, John, your head is filling my screen, so I'm going to ask you.
It's actually interesting, because I was going to comment on the last question, but it ties into this, which is, how big of a role social media and comments and everything plays into a lot of this area. And, in the Draco case, it was the prosecution's theory was that it was originating out of a rap beef. And Eric testified in that case brilliantly, by the way, and, was a significant factor in the acquittals. But in understanding that history, maybe removing it from the academic context and putting it in the historical context of how rap beefs have occurred throughout the origins of hip hop in the United States and throughout its existence. So, again, like I appreciate the academic stuff is great as far as pretrial motions and to keep evidence out, but also at the trial level, when you're in it, having an expert being able to talk about what that beef really means and how it's really a historical, and it comes out of even pre-hip hop Black traditions in the United States. So it's really fascinating, and we actually had 2 jurors who had to be talked to by the judge for walking out of the courtroom that day, saying essentially that Eric gets it, although they used a little bit more colloquial terms. The white boy gets it, essentially, or something like that. But to the comments that comes in, and I'll say this, and I think you've said this, some of the speakers have said this about the UK, the police are all over social media. And that includes YouTube, and that includes watching the videos, and that includes the comments. And so sometimes those comments can start an investigation off when somebody's talking about, oh, he's going to get on him, or he's going to do this or that. And when you think about it, these are, just like teenage fans that are gossiping, essentially. But police will say, without any knowledge of the underlying truth of it, oh, we should start following this. And you can create a case where nothing existed beforehand by following these leads. And just understanding within the policing of hip hop historically how that's happened is important for all practitioners in this field.
Well, I
know we're almost short on time, but I do want to offer at least one thought. When I was consulting with defense counsel on a case, their client was accused of homicide, and at the time of the alleged homicide, the YNW Melly song "Murder on My Mind" was supposedly playing in the background. So the government was going to argue that this was sort of motivation for the defendant, and actually in some respects kind of mimics what happened because he was accused of allegedly killing a friend. But so when we looked at the YNW Melly song online, we noticed the comment section. And so we started looking through the comment section to YNW Melly's "Murder on My Mind." And we thought, well, maybe it would be interesting to introduce these comments, because what you get is a bunch of angsty fans saying, I got murder on my mind too, right? And so the theory being, okay, everybody who's listening to this clearly does not have a criminal intent or a criminal mindset, or has not committed homicide, right? People just love the song because it's a darn good song and a darn good video. And so we were thinking of using, right, the comments in that way to suggest that clearly, right, this is not about, right, homicidal intent or homicidal actions. This is just people appreciating the song, including this particular defendant in this particular case. And so that's one way that defense counsel, right, you should also be looking through those to see what could be used against your client, but is there a way to leverage any of the comments that could be favorable to your client as well?
Well, it seems to me that as a collective, and I'm obviously separating myself from the rest of you now, that you look very much like a gang. And there are loads of comments that I can see that could quite easily be used in evidence against you. So I hope you all know a very good lawyer. We're going to close the discussion now, but it's going to carry on. And as I say, it's at a date to be set, but in 2 or 3 months' time, we're going to come back because we only got halfway through the topics. But I want to thank everybody, this side and the other side of the pond, for coming and speaking so eloquently and passionately about the issues tonight. The results of the poll are in, and I'm just going to briefly go through those, and then we're going to play out to a 1 minute 30 track. So the first question was, have you had a client prosecutor where some of the evidence used included rap or drill lyrics? 21% said yes, 23% said no. In terms of instructing a defense expert, maybe rather concerning. Only 7% had instructed a defense expert. 33% said no. Have you had rap or drill lyrics excluded from a case, and we're going back to being obsessing me now. Only 14% had been successful, 19% no, and we had obviously with all of these a number that aren't applicable. And number 4, if you've been instructed in a case where some of the evidence included rap or drill lyrics that they wrote, what's the age of the youngest defendant to have been prosecuted? So fortunately, no one under 14, but 9% were 15 to 17 years old, 7% 18 to 21, 5% over 21. So again, sad figures to end on in terms of the ages of the individuals being prosecuted in these types of cases. We're going to end with a track from Drill Minister, and it's in this context. Channel 4 commissioned him to provide a rap track using violent language. But the violent language was language that had come from current or former MPs. And he put that together to highlight the hypocrisy, the absolute hypocrisy shown against the rap, the drill genres artists. And you'll see as it played out, it's only a minute and a half, urge you to watch it, how outrageous this present situation is.
The day that it becomes, you are hurting us more than you are helping us. I won't knife you in the back, I'll knife you in the front. Team A! The moment is coming, when the knife gets heated. Twist, stuck in the front and twisted. Should be dead soon, can't stop breathing. Flowers in the grave, but your hubby and the grandma grieving. Man run things, call me Julius Caesar. All block posted, tracking sliders reefer. This gal try say that she runs contract, I'm any old geezer. I wanna arrest her, she chopped up in a bag in the freezer. That's political drilling, cutting cheese, blowing on trees. Till my party's winning. When she's a dead woman walking, caught her by downing. Getting your knees, bitch, she wasn't doing no talking. Man's talking about war, man's talking about trade, man's talking about whoring. Man's talking about money cause the roads are hot, fuck global warming. Got my YGs talking Brexit. That's no more red light district, no more subtitles on Netflix. Man, I like man on fire, and I ain't seen it up in a good while. But it ain't all doom and gloom when we get to the nigga in the wood pile. The phone don't stop, so the bond don't stop. Gotta re-up for the West Indies. Finesse these bands, band with gang, no problem, man, do it with ease. Never ever lacking, that's voodoo. Should bring a whole news to the tutu. Hit him with a boom block, hit him with a boom wham, then I puck a man like Mutu. Who the fuck do you think that you are? How many times have we gone round to the up block and the curfew that quarter to 4? Skirt, bang, hop out the car, out here freezing my locks off. Around these told her to fuck off, so she fucked off. I ain't taking no L's when it pops off. So I'm like a we bro in top shot, then it's back in the blocks for the hot box.
Maybe he says it better than any of us. So we're going to end there, but come back soon. But can I urge you to continue watching this series? The next one will take place in 2 weeks' time, 3rd of Feb, entitled Drill, Rap and Deportation. A panel of excellent speakers exploring how the Home Office uses evidence in failed prosecutions and so-called intelligence gathered through policing and monitoring of alleged gang activity as a basis for deportation in what they call Operation Nexus. So please join Garden Court in about 2 weeks' time for the continuation of this webinar. Thank you very much for joining us. Thank you to our speakers, and good night.